Hello, my lovelies from Iron Sharpens Iron. This is Trey. I have got some treats for you today, so strap in. This is going to be fun. Found a couple of cases that I thought were super cool in regards to everything I've been teaching you. If you've been following my videos as far as what we are dealing with, it being medical prescriptions, social control, we're going to take a little bit of time journey back into the 20s and up into the 40s to go over a couple of cases. I'm just going to read through them for you because I think you'll find them just as interesting as I did and horribly egregious at the same time. So this first case we're going to go over is called Buck versus Bell, 1927. I'm going to pull that case up here. It only had up the syllabus. There we go. All right, so this one is talking about a Virginia statute that provides for the sexual sterilization of inmates of institutions that are supported by the state who shall be found to be afflicted with a hereditary form of insanity or imbecility is within the power of the state under the 14th Amendment. 2, failure to extend the provisions to persons outside the institutions named does not render it obnoxious to the Equal Protection Clause. That's cute, huh? And it's affirmed. Error to a judgment of the Supreme Court of Appeals of the State of Virginia, which affirmed a judgment ordering the superintendent of the state colony of epileptics and feeble-minded to perform the operation of salpingectomy on Carrie Buck, the plaintiff, in error. Mr. Justice Holmes delivered the opinion of the court. This is a writ of error to review a judgment of the Supreme Court of Appeals of the State of Virginia, affirming a judgment of the Circuit Court of the Amherst County, by which the defendant in error, the superintendent of the state colony for epileptics and feeble-minded, was ordered to perform the operation of salpingectomy upon Carrie Buck, the plaintiff in error, for the purpose of making her sterile. This case comes here upon the contention that the statute authorizing the judgment is void under the 14th Amendment as denying the plaintiff in error to due process of law and the equal protection of law. Carrie Buck is a feeble-minded white woman who was committed to the state colony above mentioned in due form. She is the daughter of a feeble-minded mother in the same institution and the mother of an illegitimate feeble-minded child. She was 18 years old at the time of the trial of her case in the circuit court in the latter part of 1924. An act of Virginia approved March 20th, 1924, recites that the health of the patient and the welfare of society may be promoted in certain cases by the sterilization of mental defectives under careful safeguard. The sterilization may be effected in males by vasectomy and in females by salpingectomy and without serious pain or substantial danger to life. That the Commonwealth is supporting in various institutions many defective persons who, if now discharged, would become a menace, but if incapable of procreating, might be discharged with safety and become self-supporting with benefit to themselves and to society. And that experience has shown that heredity plays an important part in the transmission of insanity, imbecility. The statute then enacts that whenever the superintendent of certain institutions, including the above-named state colony, shall be of opinion that is for the best interest of the patients and of society that an inmate under his care should be sexually sterilized, he may have the operation performed upon any patient afflicted with the hereditary forms of insanity, imbecility, and so on complying with the very careful provisions by which the Act protects the patients from possible abuse. Now that's trustworthy, don't you think? I would say in order to protect society, sterilization would be enough to release someone that they consider an imbecile. I mean, it makes sense, doesn't it? These highly knowledgeable, higher educated people should definitely come up with an idea like this and think themselves to be morally correct. I don't know. This is just so appealing to me. I love this case. It's like an inside view of what your government officials, attorneys, congressmen, this is what they think. This is crazy. So although this case is from the 20s, if you've been following my videos, it is not so far off base, my friends. If we think about CPS, that's why they remove children. It's kind of like saying you're an imbecile who can't have them. And if we sterilize you, it might make the public angry. They won't like it. So instead, we'll just seek you out and like a heat-seeking missile, and we'll make sure if you ever give birth, we'll just keep taking the babies. That'll do the trick. So I thought this was a fun little case for that cause. I mean, sexually sterilizing, okay, is not good for a man, but for a woman, that's a major surgery. That's insane. And so this young woman, born to a mother who was already in an institution, I don't see how she would have ever had a chance to become a free woman or to become a woman that wasn't labeled as being feeble-minded, because clearly they believe that it's inherited. So you gotta love it. And this is not that long ago. This is in the 20s, and I have another one from the 40s. The superintendent first presents a petition to the special board of directors of his hospital or colony, stating the facts and the grounds for his opinion verified by affidavit. Notice of the petition and of the time and place of the hearing in the institution is to be served upon the inmate and also upon his guardian, and if there is no guardian, the superintendent is to apply to the circuit court of the county to appoint one. If the inmate is a minor, notice also is to be given to his parents, if any, with a copy of the petition. The board is to see to it that the inmate may attend the hearings if desired by him or his guardian. The evidence is all to be reduced to writing, and after the board has made its order for or against the operation, the superintendent or the inmate or his guardian may appeal to the circuit court of the county. The circuit court may consider the record of the board and the evidence before it and such other admissible evidence as may be offered, and may affirm, revise, or reverse the order of the board and enter such order as it deems just. Finally, any party may apply to the Supreme Court of Appeals, which, if it grants the appeal, is to hear the case upon the record of the trial in the circuit court, and may enter such order as it thinks the circuit court should have entered. There can be no doubt that, so far as procedure is concerned, the rights of the patient are most carefully considered. Yeah, I'm sure they are behind closed doors and walls of an institution where no one can see in, and the guy thinks that it's okay to do a major surgery on a woman simply because he doesn't like the way she thinks. As every step in this case was taken in scrupulous compliance with the statute, and after months of observation, there is no doubt that in that respect, the plaintiff in error has had due process of law. The attack is not upon the procedure, but upon the substantive law. It seems to be contended that in no circumstances could such an order be justified. You think? It certainly is contended that the order cannot be justified upon the existing grounds. The judgment finds the facts that have been recited, and that Carrie Buck, quote, is the probable potential parent of a socially inadequate offspring, likewise afflicted, that she may be sexually sterilized without detriment to her general health, and that her welfare and that of society will be promoted by her sterilization. How exciting, Carrie Buck. You are the potential parent of a socially inadequate offspring. We cannot let you go free, Miss Buck, because you might reproduce. However, if you allow us to do a major surgery to sterilize you, we believe that you may walk freely amongst society and that it will promote the general welfare of the society, knowing that you can't make babies. Anyone? Anyone? Bueller? These are the people proclaiming to have a higher level of knowledge and superiority to determine and choose who is somehow morally less of a person than they are. And I can't imagine very many people would agree that that was a moral decision made by some expert board that led the legislator to actually enact this law that actually had to go all the way up to the Supreme Court because everybody agreed, who was a bar member, that sterilization of a woman would be a benefit to society, and therefore she can only be free if she offers society said benefit. You gotta love it. And thereupon makes the order in view of the general declarations of the legislature and the specific findings of the court. Obviously, we cannot say as a matter of law that the grounds do not exist, and if they exist, they justify the result. We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices. The lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, you hear that? To let them starve, meaning we're going to kick them out of society, not allow them to get a job, not allow them to partake in, participate, or contribute to the economics of the society because they're imbeciles and likely to someday commit a crime probably, and they don't even know this. They don't even know this, but this is what they decided, that that's a possibility. And we still have this same mindset. That's the scary part. Anyways, let them starve for their imbecility. Society can prevent those who are manifestly unfit from continuing their kind. Oh my God, they're playing God. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough. Who's the real imbecile? Oh my God, help me, please. Somebody tell me this is, I'm not the only one who thinks this is completely insane. But it says, however, it might be if this reasoning were applied generally. It fails when it is confined to the small number who are in the institutions named and is not applied to the multitudes outside. It is the usual last resort of constitutional arguments to point out shortcomings of this sort. But the answer is that the law does all that it is needed when it does all that it can, indicates a policy, applies it to all within the lines, and seeks to bring within the lines all similarly situated so far and so fast as it means allow. Of course, so far as the operations enable those who otherwise must be kept confined to be returned to the world, and thus open the asylum to others. The equality aimed at will be more nearly reached. Oh yeah, Justice Bullard v. DeSensa. What? So, if we sterilize them so they can't make babies, that's equity because it will open up another bed for another imbecile. So whoever needs that bed, they'll get it. This person will get out of there. But this person will be doing a justice to society because they won't make any more babies because society doesn't like them. And neither do these judges. I don't know which society they're talking about because I would be willing to bet the other people at that time were probably not really rich people. They were probably not all judges, attorneys, and psychologists. So whose society are they referring to? It have to be their own. I don't know who comes up with this stuff. Or I don't know, maybe you think it's a good idea. I think that's crazy. So there's another case that led me to that case that was even better than that one. This one is Skinner versus Oklahoma. And this one is from 1942. It was a certiorari to the Supreme Court. Same scenario, but this is a gentleman. And he was going to be snipped because they considered him to be a habitual criminal. So what were his crimes? He stole some stuff and did a couple of armed robberies. And he is arguing that the statute is providing unequal protection under the law because this particular statute allows for exceptions. So only certain criminals or certain habitual criminals would end up being sterilized, and other criminals, habitual criminals, as long as they were white-collar crimes, were exempt from being sterilized. So if you steal something 3 times, then you would be subject to sterilization. If you're a congressman, senator, or a judge who commits crimes 3 times, or a rich corporation owner, then you would not be sterilized. So what they're saying in this case is that if you're just your average Joe committing crimes and you do 3 of them, you should be sterilized, and we don't want any more of your babies running around here, because if we had more of your babies around here, they would be undesirable. However, if you are rich and have a professional career with the bar, then you can commit all the crimes you want. We want more of those babies. Just makes sense, doesn't it? Just makes sense. I don't know what we're thinking. When we think about equality, what are we thinking? We must be crazy. The state Supreme Court, having sustained this act as applied to the petitioner here without reference to severability cause, the question whether the clause would be so applied as to remove the particular constitutional objection is one which may appropriately be left for adjudication by the state court. So they actually passed on answering a part of the constitutional question in this case, meaning that they don't want to answer it, they don't want it on the record. So I thought that was kind of fun and fantastical in and of itself, but we'll talk about what he did here. So a habitual criminal being defined therein is any person who, having been convicted 2 or more times in Oklahoma or in any other state of felonies involving moral turpitude, is thereafter convicted and sentenced to imprisonment in Oklahoma for such a crime. Expressly accepted from the terms of the statute are certain offenses, including embezzlement, as applied to one who was convicted once of stealing chickens and twice of robbery, held that the statute violated the equal protection of the 14th Amendment. Well, here, brothers and sisters, I would have to agree with that. Makes absolutely 0 sense. 0, absolutely none. So the affirmance of a judgment in a proceeding under the Oklahoma Habitual Criminal Sterilization Act, wherein it was ordered that the defendant, petitioner here, be made sterile. Mr. Justice Douglas delivered the opinion of the court. This case touches a sensitive and important area of human rights. Yeah, duh. Oklahoma deprives certain individuals of a right which is basic to the perpetuation of a race, the right to have offspring. Oklahoma has decreed the enforcement of its law against petitioner, overruling his claim that it violated the 14th Amendment because that decision raised grave and substantial constitutional questions. We granted the petition for certiorari. The statute involved is Oklahoma's Habitual Criminal Sterilization Act. The act defines a habitual criminal as a person who, having been convicted 2 or more crimes amounting to felonies involving moral turpitude, either in Oklahoma court or in any other court of this other state, is thereafter convicted of such felony in Oklahoma and is sentenced to a term of imprisonment in Oklahoma Penal Institution. Machinery is provided for the institution by Attorney General of a proceeding against such a person in the Oklahoma courts for a judgment that such person shall be rendered sexually sterile. Notice and opportunity to be heard and the right to a jury trial are provided. So it's okay. As long as you get all that, it's okay to subject someone to some sort of horrible procedure, medical dangerous procedure. Who cares, right? For stealing some chickens. These people, they're special. Anyways, offenses arising out of the violation of the prohibitory laws, revenue acts, embezzlement, or political offenses shall not come or be considered within the terms of this act. Like I said, if you work for the government, if you have a lot of money in your pocket and are rich with, businesses, and if you are a bar member, of course, you will not be sterilized if you are a habitual criminal. That's an acceptable form of criminal persons or people. They should reproduce more of themselves and less of everyone else who steals chickens. Petitioner was convicted in 1926 of the crime of stealing chickens and was sentenced to the Oklahoma State Reformatory. In 1929, he was convicted of the crime of robbery with firearms and was sentenced to the Reformatory. In 1934, he was convicted again of robbery with firearms and was sentenced to the penitentiary. He was confined there in 1935 when the act was passed, and in 1936, the Attorney General instituted proceedings against him. Petitioner, in his answer, challenged the act as unconstitutional by reason of the 14th Amendment. A jury trial was had. The court instructed the jury that the crimes of which petitioner had been convicted were felonies involving moral turpitude, and that the only question for the jury was whether the operation of vasectomy could be performed on petitioner without detriment to his general health. And the jury found that it could be. Really want a jury trial? A judgment directing that the operation of vasectomy be performed on petitioner was affirmed by the Supreme Court of Oklahoma by 5-4 decisions. Why would a jury decide that that was okay? I can't even imagine. Several objections to the constitutionality of the act have been pressed upon us. It is urged that the act cannot be sustained as an exercise of police power. I would have to agree. In view of the state of scientific authorities, so in view of the state of scientific authorities, we have those today: National Institute of Justice, National Institute of Health, your various committees sitting in the seats of Congress. So when we talk about scientific authorities, this is where they get their ideas today. When they develop a statute that has a model of duty of care, such as a parent and a driver and so forth and so on, it comes from these scientific authorities. Same people. Next step probably will be sterilization. Just waiting for it. I don't even know if this is on the books or not anymore. It might just be. I didn't, check on the case or anything, but I just found it interesting. It is argued that due process is lacking because under this act, unlike the act upheld in Buck versus Bell, that's the case we just read, the defendant is given no opportunity to be heard on the issues as to whether he is the probable potential parent of a socially undesirable offspring. It is also suggested that the act is penal in character and that the sterilization provided for is cruel and unusual punishment in violative of the 14th Amendment. Yeah, duh. We pass those points with intimating an opinion on them, for there is a feature of the act which clearly condemns it. That is its failure to meet the requirements of the Equal Protection Clause of the 14th Amendment. We do not stop to point out all of the inequalities of this act. A few examples will suffice. In Oklahoma, grand larceny is a felony. Larceny is grand larceny when the property taken exceeds $20 in value. Embezzlement is punishable in the manner prescribed for felonious stealing property of the value of that embezzled. Hence, he who embezzles property worth more than $20 is guilty of a felony. A clerk who appropriates over $20 from his employer's till and a stranger who steals the same amount are thus both guilty of felonies. If the latter repeats his act and is convicted 3 times, he may be sterilized, but the clerk is not subject to the pains and penalties of the act, no matter how large his embezzlements, nor how frequent his convictions. A person who enters a chicken coop and steals chickens commits a felony, and he may be sterilized if he is thrice convicted. If, however, he is a bailee of the property and fraudulently appropriates it, he is an embezzler. Hence, no matter how habitual his proclivities for embezzlement are, and no matter how often his conviction, he may not be sterilized. Thus, the nature of the two crimes is intrinsically the same, and they are punishable in the same manner. Furthermore, the line between them follows close distinctions comparable to those highly technical ones which shaped the common law as to trespass or taking. Bishop Criminal Law, 9th edition. There may be larceny by fraud rather than embezzlement, even where the owner of the personal property delivers it to the defendant, if the latter has at that time a fraudulent intention to make use of the possession as a means of converting such property to his own use, and does so convert it. If the fraudulent intent occurs later and the defendant converts the property, he is guilty of embezzlement. Whether a particular act is larceny by fraud or embezzlement thus turns not on the intrinsic quality of the act, but on when the felonious intent arose, a question for the jury under appropriate instructions. It was stated in Buck versus Bell that the claim that the state legislation violates the Equal Protection Clause of the 14th Amendment is the usual last resort of constitutional arguments under our constitutional system. The state is determining the reach and scope of a particular legislation need not provide abstract symmetry. They may mark and set apart the classes and types of problems according to the needs and as dictated or suggested by experience. See Bryant versus Zimmerman and cases cited. It was in that connection, Mr. Justice Holmes, speaking for the court in Bain Peanut Company versus Pinson, stated, quote, "We must remember that the machinery of government would not work if it were not allowed a little play in its joints." That was a judicial opinion. How lovely is that? I don't know what to say. But I just want to kind of throw it out there. Is this sounding painfully familiar when we talk about equal protection under the law? And this is explaining that that means pains and penalties must be applied to any party equally for the same type of crimes. And it seems that the judicial immunity or any type of qualified immunity would be in violation of equal protection under the law. If I were correct on that, I'm not really sure what kind of game we're playing with these psychos at this point, but this is insane to me that we have a case that basically breaks that down. And although, yes, it is from the 20s and things change, the fundamental foundational principles should not change. But maybe I'm socially defective and I can't make that kind of logical and reasonable thought and process it that way that they can. I don't know. We'll carry on. So we must remember that the machinery of government would not work if it were not allowed a little play in its joints. Only recently we reaffirmed the view that the Equal Protection Clause does not prevent the legislature from recognizing degrees of evil. By our ruling in Tigner versus Texas, that the Constitution does not require things which are different, in fact, or opinion to be treated in law as though they were the same. Thus, if we had here only a question as to a state's classification of crimes, such as embezzlement or larceny, no substantial federal question would be raised. Seymour versus Missouri and a bunch of other cases. For a state is not constrained in the exercise of its police power to ignore experience which marks a class of offenders or a family of offenses for special treatment, nor is it prevented by the Equal Protection Clause from confining its restrictions to those classes of cases where the need is deemed to be clearest. The law does all that is needed when it does all that it can, indicates a policy, applies it to all within the lines, and seeks to bring within the lines all similarly situated so far and so fast as its means allow. And see, my thoughts on this is about the injuries sustained as well when we think about equal protection, because if my act causes for someone to be injured in the sense that maybe their liberty interest has been abridged and they end up, say, I don't know, say they fell into a well and were stuck there for a week or two. This is no different than the injury sustained by a human who is put in prison. Yet, that would mean that if it was a cop who puts you in prison, he is not subject to any criminal charges if he did so without the proper authority and purpose. But if you dropped his butt in that well, yeah, you'd be subject to all kinds of criminal charges. So, sort of as a creation of a privileged class, I'm saying, and yeah, I'm not sure why people would agree that certain classes of persons should receive penalties and other classes of persons who do the same types of crimes should not receive penalties, or that those penalties should be somehow a lot of more a lot more hard to bring to bar. You even if you can get them out of their immunity status, you're going to be in court for years, where for them they have this team in there that takes a couple of days. So I find that very interesting when we read this case. But the instant legislation runs afoul of the Equal Protection Clause, though we give Oklahoma that large difference which the rule of the foregoing cases requires. We are dealing here with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the race. The power to sterilize, if exercised, may have subtle, far-reaching, and devastating effects. In evil or reckless hands, it can cause races or types which are inimical to the dominant group to wither and disappear. Yeah, that's happened. I don't know if they knew that or not, but, perhaps their education wasn't the same back then as it is today. Don't know. There is no redemption for the individual whom the law touches. Any experiment which the state conducts is to his irreparable injury. He is forever deprived of a basic liberty. We mention these matters not to re-examine the scope of the police power of the states. We advert them to merely in emphasis of our view that strict scrutiny of the classification which a state makes in a sterilization law is essential, less unwittingly or otherwise. Invidious discriminations are made against groups or types of individuals in violation of the constitutional guarantee of just and equal laws. The guarantee of equal protection of the laws is a pledge of the protection of equal laws. Yikwo versus Hopkins. When the law lays an unequal hand on those who have committed intrinsically the same quality of offense and sterilizes one and not the other, it has made as invidious a discrimination as if it had selected a particular race or nationality for oppressive treatment. What do you think, friends? Do you think when certain classes of persons, aka non-governmental persons, are able to be punished for crimes, but governmental persons can commit the same crimes and not be punished for them because of immunity, would this mean that there is some sort of oppressive treatment? I'll let you be the judge. Yikwo versus Hopkins Supra, Gaines versus Canada, 305 U.S. 337. Sterilization of those who have thrice committed grand larceny with immunity for those who are embezzlers is a clear, pointed, unmistakable discrimination. Let me say that again, my lovelies. Sterilization of those who have thrice committed grand larceny with immunity for those who are embezzlers is a clear, pointed, unmistakable discrimination. Oklahoma makes no attempt to say that he who commits larceny by trespass or trick or fraud has biologically inheritable traits which he who commits embezzlement lacks. Oklahoma's line between larceny by fraud and embezzlement is determined, as we have noted, with reference to the time when the fraudulent intent to covert the property to the taker's own use. We have not the slightest basis for inferring that the line has any significance in eugenics, nor that the inheritability of criminal traits follows the neat legal distinctions which the law has marked between those two offenses. In terms of fines and imprisonment, the crimes of larceny and embezzlement rate the same under the Oklahoma Code. Only when it comes to sterilization are the pains and penalties of the law different. The Equal Protection Clause would indeed be a formula of empty words if such conspicuously artificial lines could be drawn. The Virginia statute was upheld, though it applied only to feeble-minded persons and institutions of the state, but it was pointed out that so far as the operations enable those who otherwise must be kept confined to be returned to the world, and thus open the asylum to others, the equality aimed at will be more nearly reached. Here there is no such saving feature. Embezzlers are forever free. Those who steal or take in other ways are not. If such a classification were permitted, the technical common law concept of a trespass, based on distinctions which are very largely dependent upon history for explanation, could readily become a rule of human genetics. It is true that the Act has a broad severability cause, but we will not endeavor to determine whether its application would solve the equal protection difficulty. The Supreme Court of Oklahoma sustained the Act without reference to the severability cause. We have therefore a situation where the Act, as construed and applied to petitioner, is allowed to perpetuate the discrimination which we have found to be fatal. Whether the severability clause would be so applied as to remove this particular constitutional objection is a question which may be more appropriate left for adjudication by Oklahoma court. That is reemphasized here by our uncertainty as to what excision, if any, would be made as a matter of Oklahoma law. It is by no means clear whether, if an accession were made, this particular constitutional difficulty might be solved by enlarging on the one hand or contracting on the other the class of criminals who might be sterilized. Healy, the individual delinquents, Southern criminology, criminology and penology. These are all the books that you can look at. I guess you can just go and pull this case and you can find all the different little references. But the point is, anyway, I don't even know what to say. I'm just so, this is so fantastical. It's just so fantastical. I can't even wrap my head around it because it's not just about the Equal Protection Clause. What they just said here is that they are picking and choosing who they want to procreate and create babies for the future. And it's I don't know. I can't even get into the thought of something like this right now. Crazy. But I don't know. You guys go ahead and read this case. There's a few of them. I could go on all day with these cases. These are fun. I like these. Like I said, I haven't checked to see if it was overturned. I haven't did a lot of research on it because I just started reading it. So I wanted to share it with you because I just found it very, very interesting. And, hit me up in the comments. Let me know if you have any questions. Let me know what your thoughts are on these people thinking that they have some sort of scientific psychic ability to determine who is socially acceptable or who is not. Maybe I'm wrong. Let me know in the comment section. Hit the like button, hit the bell to make sure that you get notifications for our next videos. If you like what you heard here today, subscribe if you have not already. And everybody have a fantastic day.